Hi, everybody. Nice to see you. Hey, Joe. Good to see you. I'm glad you're back. Nice to see you. The sun is back with us, right? Which is a beautiful thing. Hey, Madeline. Good to see you. Um, Man, nice to see everybody. Thanks for coming out. It's a little cloudy out there, but way warmer than the last time we talked. Um, so thanks. We got some big numbers today, and we're going to be talking about, hopefully for the last time this year, snow, sidewalks, immunity, and disability, right? Because we don't all know it yet, but you're still going to be getting slip and fall claims whether you like it or not, right? Oh, hey, Greg. Um, you can sit down. I like the Rutgers sweatshirt there, Greg. Thank you. The So it's good to see everyone. We'll go through some announcements first. So, Crystal, we have dog of the day. We'll go with dog of the day. So we have dog of the day, and dog of the day is Mackie, and Mackie belongs to Jeannie Connors. If anyone works with Jeannie Connors from Realty Solutions, they're based in the Collingswood, Haddon Township area. And then they also have a big presence in Atlantic County and Ocean County. So that's Jeannie's dog, Mackie. And that's a 6-year-old long-haired dachshund, very fancy. And that's Jeannie's grand dog. But Jeannie's grand dog lives with Jeannie right now. You know how that works out. Your kids get a dog and don't feel like taking care of it. And guess who takes care of it for the rest of their lives? Jeannie, you got it. Jeannie's taking care of that. But beautiful dog, you got lucky there, Jeannie. A beautiful grand dog. Thank you. And on the note of the dogs, we need dogs. So if you haven't submitted your dog yet, we do need some dogs for next month and the following month, so we can flesh out the 2027 calendar. So please, if you have dogs, even if they're grand dogs or step dogs, send the dogs in. The next thing we have is first day of spring, I guess, is coming up, right? So that's good. On the 20th, we also have St. Patrick's Day. Everyone is Irish on the 17th. So that's a good day. So everyone, I hope, has fun with that. Daylight savings time. We have a full calendar. Daylight savings time, I think, is coming. Is it Saturday or Sunday? Maybe Sunday. Sunday, yeah. So Sunday. So that'll be a big deal. We'll have a lot of sunshine there. Then I got to do our regular announcements, which is, this is not legal advice. General informational purposes only, educational only. The No attorney-client privilege here, no attorney-client relationship, and nothing gets kept confidential. So if you want to have a lawyer, if you want legal advice, just give me a call. We'll sign a fee agreement, and we'll be happy to get to work for you. But this is just an educational seminar, webinar, I guess, right? One of these days we should do one of these live and in person and have like a big fancy luncheon or something. That would be fun. So a live one would be good. So let's just jump right into it. We had dog of the day. So property use versus property ownership and control. So historically, that second agenda item there, residential use versus commercial use. So historically in New Jersey, the law did not impose. There was an exception to the common law for residential use, and liability was not imposed by the courts for residential use, but it was imposed for commercial use. Okay, so that's been a very clear distinction in New Jersey law for a long time in terms of liability. And I don't think I have it on your agenda, but the cases that really got into that was a 2011 case and there are lots of cases, but this was a New Jersey Supreme Court case from 2011, Lushenko versus Skyline Condo Association. So Lushenko versus Skyline Condo Association. If you're really interested in that and reading case law, I can send you a copy if you want. But Lushenko, what happened to Lushenko? So it was up in Hoboken, and Mr. Lushenko, it had snowed like 2 days before, and everyone knows what happens. It cleared the snow, and 2 days later, you have melt and refreeze. And Mr. Lushenko was walking to work in Hoboken, past the Skyline condo, and he was not a hustler. He actually was injured. He slipped and fell about 6:30 in the morning on black ice, which referred to as black ice, which we know there's no such thing as black ice, but it's that kind of layer of ice that looks kind of black at times because it just has a sheen on it, and sometimes it's very difficult to see. So he actually broke his leg, though. He actually did break his lower leg, so he was truly injured, and so he sued the condo association. The condo association there, apparently based on the court's opinion, did not own the sidewalk, did not own where the sidewalk was. They did, however, do some snow remediation, salting work, etc., around the association and the sidewalks around there, but they didn't own it, and the building was a residential property. The unusual thing there was it was a 104 unit residential property, but on the first floor they did have commercial. They did have some commercial in the building, but what the court found that it was overwhelmingly residential. That the association didn't own the sidewalk, and therefore there was no imposition of liability on the condo association. So it didn't work out for Mr. Lushenko. The court did not impose liability on the association. What do we take away from that? We take away from that if it's residential, generally speaking, and a public sidewalk. So let's keep that in mind, residential and a public sidewalk. So the sidewalk in the city next to Hoboken, next to Silent Condo, was a public sidewalk. Okay. So keep that in mind. Not only was it a residential use that was appurtenant to the sidewalk, it was also a public sidewalk rather than a sidewalk owned by the association. So Lushenko said, nope, I'm sorry. The Lushenko case said, no, Mr. Lushenko, the association is not liable. You got to go on your way and figure out another way to get your leg fixed. One thing that the Lushenko case did highlight, which is a really important thing for us, is it talked about ordinances directing private persons to care for public property. I'll repeat that again. Ordinances directing private persons to care for public property. Why is that important? It's important because, so that's an example of an ordinance. This one, in fact, comes from Brick Township, but many ordinances are the same. And it says, each owner or tenant of land abutting or bordering upon the sidewalks and streets shall keep the sidewalks in front of the premises in a safe, passable, and orderly condition, free from snow, ice, grass, weeds, and other impediments. In case there is snow or ice on the sidewalks, such person shall remove the same within 24 hours of daylight, after the snow shall have ceased falling, or after the ice has formed. Right. So what happened in Lushenko, stop share, was there apparently Hoboken had some type of ordinance that said something like that. So you're like, Fran, how does that work then? The town or the city or what have you says, hey, if you're next to the sidewalk, even if it's a public sidewalk, you have a duty to remove the snow. And what the Lushenko court said was, that's all well and good, but it has long been the law in this state that breach of a municipal ordinance directing private persons to care for public property shall be remediable only at the insistence of the municipal government, and that there shall be no right of action to the individual citizen. So what that meant was, even if there was an ordinance in Hoboken that said the property owner next to the sidewalk must clear the snow, it doesn't provide the person injured with a private right of action. It does provide the city with the ability to issue a summons or a fine for not clearing the snow, but it doesn't give the person who got injured a private right of action. Does that make sense? Right? So it's a real distinction that sounds weird at first because you're like, well, golly, there's a law that says you got to clear it. So you got to clear it. And if you don't clear it, there's going to be a problem. The reason I am very sensitive to those types of ordinances right now is I have a large client in Lakewood, New Jersey, that over the last snowstorm where the ice formed on the layer on top, the association did not clear the snow in time under the Lakewood statute. And this is crazy, in my opinion, but Lakewood Township issued 5 summonses for $1,000 a piece against the association for not timely removing the snow from the sidewalk. Okay, so that's really annoying, and we're going to fight that. But so even though there may be an issue in terms of insulation from personal liability, you still may be fighting an ordinance violation and a summons from the town if you don't do what you're supposed to do under the ordinance. So that's Lushenko. So that's the issue of basically commercial versus residential, and whether or not a municipal ordinance imposes a right to sue on the injured person, and generally it does not. Okay, so that's Lushenko. So then let's talk about association owned versus publicly owned and controlled or in the right of way. So association owned versus publicly owned. So when we talked about the Skyline case, um, the sidewalk was a public sidewalk. It was not owned by the association. So this fact pattern is different. And the case we're talking about here is Quan versus Cranberry Brook HOA. Quan versus Cranberry Brook HOA. How is the Quan case different? Mr. and Mrs. Quan were walking back. I think they went grocery shopping, and why not in the middle of a snowstorm? But what else would you do? That's like all the people in our communities, right? At most of them, they're like, it's the middle of a blizzard and you haven't cleared the snow yet because I have to get my mail. Or you could wait to get your mail until tomorrow, right? You could wait to get your mail until tomorrow, but that would not be possible because then I wouldn't break my pelvis, right? Let's everyone pause, give your mail an extra day, and let's not break your pelvis, right? We don't want to see anyone get hurt. Everyone can take their time. Generally speaking, you don't got to get to your mailbox tomorrow morning. But anyway, I digress, which I'm known to do. But so what happened in Quan was they went out shopping either in the middle of a snowstorm. I don't want to disparage the Quans. I'm sure they're very nice, smart people. They went out shopping. They came back and they were walking through the Cranberry Brook HOA. This time, though, it was on a sidewalk that went through the middle of the community, not appurtenant to a roadway. It was not a public right of way. It was not a public sidewalk. So what happened was Mrs. Kwan fell and was injured significantly, and she sued the association. And the association's insurance carrier's attorney said, "Ha ha, we know how this works. We are going to beat Mrs. Kwan. She'll get nothing. We are going to cite that case from a couple of years ago. It was 4 years prior, was the Lushenko case. And we know that since we're a residential community, we're not going to have to pay Mrs. Kwan a dime. Good luck, Mrs. Kwan. You're going to be just like Mr. Lushenko." And they, of course, said, no, nope, Mrs. Kwan wins. Mrs. Kwan wins here because the association owned and controlled the sidewalk. This was not a public sidewalk. This was not a sidewalk that was appurtenant to a public right-of-way. This was not a public property. This was the association's property. And the court talked about some things that many of us have to think about in the sidewalk realm. Who owns and controls the sidewalk? The court also talked about what the governing documents say about the association sidewalk. What are the duties with respect to the sidewalk? And does the association have insurance on the sidewalk? You see what I'm saying? So sometimes you got to look at your insurance policy too, because the court mentioned insurance in terms of distinguishing it from the Lushenko case, because I cannot get insurance, and neither could the Skyline Association get insurance on public property, right? But what the court said in Quan was, hey, that's your property, that's your sidewalk, it's insured, it's under your policy. Not only do you own and control it, you also have the duty to maintain it in your governing documents. And on top of all that, you have insurance on it, right? So which means you got to deal with it. So that was a winner for Mrs. Kwan, right? So that was a winner for Mrs. Kwan. The reason I have the three topics there is as things get into the public right away, things get a little more dicey, right? So, and I'll talk about the next case in a second. So there's kind of three scenarios: association owned, which clearly in the Kwan case, the association owned the sidewalk, as opposed to the publicly owned sidewalk in Lushenko. And then there is, well, what if the association owns the sidewalk along a roadway that is dedicated to the public or the township? So not all, but many of our associations have roadways that are they're owned by the association, or they were owned at one point, and then they were dedicated to the public, or even if they weren't dedicated to the public, there's a roadway that has a right of way. The association may still own the property, but there's a right of way to the public, and the sidewalk is within the right of way. Things are a little gray there. Things are a little gray there, and the Supreme Court hasn't come down with a real black and white clear decision on that. And for those of you who aren't familiar with this, I'm going to share my screen again. Okay, so this is kind of an engineering drawing from it's New Jersey Government Engineering Manual from 2022. And this shows what a public right-of-way generally is. So it'll say, a 50-foot, for example, public right-of-way. So there's your curb line. There's your curb line over here. And even though this home may own their lot all the way to the curb line, the public right-of-way will extend in many cases beyond the sidewalk. So we see the sidewalk down here. See the sidewalk down here? So even though this home may own their lot all the way to the curb, there's a public right-of-way that goes from this line to this line. So there's an argument that even though this sidewalk may be owned by this house in the homeowners association, or may in fact be owned by the association itself, that the public right-of-way takes control of that property away from the homeowners association or away from the owner themselves and puts it on the public right-of-way or the state or the municipality instead of the private person. The law is not super clear on that, not super clear, but I'm going to talk about an appellate division decision that talks about that in a second. So now we're going to talk briefly and keep this public right-of-way in mind about ownership may not equal control and may still be public. And that's generally speaking about the public right-of-way. So there's a case called Walder versus Piper One Townhome Association. And in that case, it was a condominium association, like say this was the condo association. It was one building, and somebody was walking down the sidewalk this way, and it was a condo association though. So the testimony was not super clear, but it seemed like the ownership of the common elements went all the way to the curb, all the way to the curb. But the condo association did not own the road. The court, and it was the appellate division rather than the New Jersey Supreme Court, the court there said, well, wait a second. We're looking at all the facts surrounding the use of this sidewalk. And number one, it seems like in the public right-of-way, even though it might be part of the association's condo common elements in terms of ownership, but in addition to that, the people who walk on this sidewalk go to other areas of the public. They're not just limited to this sidewalk to the homeowners association. So like in many retirement communities, for example, you come within the gates, and these sidewalks only loop into private property. They don't continue to any other public property or access other public properties, right? They stay within the association. In this case, though, in the Walder case, the sidewalks, even though they may have been on common elements, linked and connected to other properties in the public domain. And what the court said was, based on the facts that had been testified to at trial, it was very, very clear that regardless of whether or not the association owned the property itself, this sidewalk was used by the public and was very likely within the public right-of-way. So there, the court said, no, we're not imposing liability on the association. The association is residential use. The association does not have control over this sidewalk. It clearly is connected to other public sidewalks throughout the public areas. So that's a case where it's a gray area, and I'm involved in a case right now. It's not a slip and fall case. The association is just kind of debating what they want to do with their sidewalks. And in that case, it looks like the association owns the sidewalks. So it looks like it's on association property rather than lot owner property. However, there's a 50-foot right-of-way that may encompass the association sidewalks. We just need an answer on that from an engineer as to whether the right-of-way is encompassing the sidewalks. And we also need a representation from the association's insurance carrier. Hey, do we have coverage on those sidewalks? Right? Because that weighs in the balance too. So just because you have ownership, it might not equal control, and it may still be public. These sidewalk liability cases are very, very complex and very fact sensitive. Why does it matter to you if you're just turning the slip and fall over to your carrier? The reason it's very important to you as association board members is the last thing you want is the association's carrier just paying out big settlement fees if you have a real basis for fighting the case. Many association insurance defense attorneys, not all, but many of them are not very well versed in the nuances of association law, and they won't always recognize the exceptions to liability in the sidewalk realm, right? And the association will wind up with a significant loss run that it may have been able to avoid. Consistent with that, I have a note here that says a quick word about the immunity amendment. As you know, the immunity amendment, and I think, most people should consider it if you don't have it already. That is bodily injury claim immunity vis-a-vis the homeowner or the unit owners, as long as it's an amendment or as long as it's a provision in your governing documents, your bylaws. But it's only as to the unit owners themselves. And it's interesting because it came up in the Kwan case. In the Kwan case, Cranberry Brook, who wound up losing the case, actually had the immunity statute in their governing documents. They did. The problem there was the titled owner of Mr. and Mrs. Kwan's house was the son, not them. Even though they lived there, they were not record owners. The son owned it. And so the Insurance Defense Council raised the immunity amendment provision in the governing documents as a defense, and the court said, yeah, not so fast. They're not homeowners. They're not record owners of the property. Therefore, it doesn't apply to them. The appellate court said, you can try, if you go back down to the trial level and fight about that, and try to construe them as unit owners because they do live there. But I think that they would have lost that even if it was remanded to the trial level. The statute is pretty clear, in my opinion. So keep in mind, think about the immunity statute. I have seen a number of cases in associations where the association actually had the immunity statute language in the governing documents, and the carrier just paid to settle the case and make the person go away, right? So you're like, wait a second, should we have done that? It's fine. We have insurance if someone gets hurt, and the association is liable. That's why we have insurance. But if the association is not going to be liable, why have the loss run if you don't need to? Okay. So that's a quick word about immunity amendment. So snow and ice and disability. Why did this come up? So we mentioned this very briefly last time when we were talking about snow budgets and how much people are going to have to special assess for snow, blown snow budgets. By the way, the time to special assess is coming up. You should do it soon, right? I mean, start thinking about, we're in March, thinking about April, May at the latest, perhaps, if your budget is blown up with snow charges, because as I said last time, if you wait till June, July, August, or God forbid next fall, and put a special assessment, all your members will be like, what snow are you talking about? Why are you trying to screw us? Right? And you'll be like, I don't know, all that snow we had last year, it was insane. And they'll be like, we don't remember any snow and we don't want to pay for anything. Leave us alone. Right? We don't want that. Right? So if your budget is blown over snow, make sure you think about a special assessment very soon. But back to snow and ice and disability. Why do I have the words "don't be foolish" in there? So after last month's First Friday with Fran, a number of questions came in, and they said, we heard that it was a law that anyone who was on dialysis had to be the number one cleaned out for their snow. And if anyone was on chemotherapy, they had to be number one out for their snow. And if anyone had a nursing aide that comes in and, takes care of them because they're disabled, they had to be number one for the snow. That's generally not the case. However, and this is the don't be foolish. What applies to associations through the Fair Housing Act? The Fair Housing Act basically says disabled people have to be able to share in the association's facilities and common elements and common property on a reasonably equal basis as everyone else. Generally speaking, disabled people are not able to do that without reasonable accommodations. So if they ask for reasonable accommodations, you have to engage, you being the association, the board and management, in a constructive dialogue to figure out what's reasonable and what's not, right? What's reasonable, not, right? So it's not a blanket thing. It's really a person by person, case by case, request by request for a reasonable accommodation. Okay, because not every just because someone has a need for dialysis doesn't mean they need dialysis every day. It doesn't mean they need it 3 days a week. They may not. They may need it less. You know, fortunately or unfortunately, kidney disease has it's not an on or off type thing. Some people have various degrees of kidney function. Um, so and obviously that's not the only disorder, kidney disorder that requires immediate care. Things like chemotherapy may be as well. So it's individual to individual with respect to the disability. So I have two cases for you to think about on the disability accommodations. I did not find published decisions on the disability accommodations with respect to snow removal in New Jersey, but I was lucky enough to find two cases in other states. One's in Michigan, right, which can get pretty darn cold, and one is in Colorado, which can get pretty darn cold too, and they get a bunch of snow, right? In fact, a lot of people go to Colorado just for the snow. And one of them is an apartment case, and one of them is a condo association. Even though there's a little bit difference in terms of ADA application, Fair Housing Act application, there are very similar themes, and I don't think you're going to see huge distinctions in terms of people requesting reasonable accommodations for disability with respect to snow and ice removal. The first one I'm going to talk about is it's called Bachman versus Swan Harbor Associates, and that was the landlord-tenant one and comes out of Michigan. But this is how crazy people are. The Court of Appeals held that a landlord's duty to accommodate required those reasonable accommodations necessary for a tenant's enjoyment of the present premises as they relate to rules, policies, practices, or services, and only when accommodation would result in undue hardship. So that's the reasonable accommodation test, right? Let's talk about the plaintiff. So the plaintiff was Ronald Bachman. So we're talking, this is probably the second paragraph in the court's decision. Somebody actually took this to trial, right? Somebody actually took this case to trial. And this is how the case starts. Plaintiff was born with a disease that required amputation of both his legs at the age of 4. Does anyone on the call today think the landlord is going to win that case? No way. No one is putting Ronald Bachman in front of a jury and is thinking they're going to win, right? No, you settle that case, right? You settle that case. So Ronald Bachman continued with the case. So he lost his legs. But this is how tough Ronald was. For most of plaintiff's adult life, he has moved around by walking on his hands rather than using prosthetic devices. Okay. So this is the court talking. I can't believe this thing went to trial, right? In February of 1988, however, he and his daughter moved into a regular apartment in the Swan Harbor Apartments. However, in 1995, after plaintiff injured his back in an accident, he began to rely on a motorized scooter for mobility rather than walking on his hands, right? I mean, that's a tough guy right there. Okay. And obviously the court recognizes that. So the court goes on. The plaintiff testified that he had complained regarding problems he had with maneuvering his scooter in the snow. Plaintiff described times when he had to get off his scooter after becoming stuck and remove snow with his arms in order to gain access to his apartment building. Plaintiff testified that the snow and ice were allowed to accumulate for a day or longer before the defendants took steps to remove it. There was also testimony from at least one other witness that the complaints were made to the defendants regarding the lack of snow and ice removal in front of the plaintiff's apartment. Craziness, right? Craziness. Who would let this go to trial? So what was the verdict, right? Everyone knows the verdict. Mr. Bachman won. Mr. Bachman won, right? How much did Mr. Bachman win? $3,837,000, $965.80. That's what Mr. Bachman got in the verdict. That's what Mr. Bachman got. So that was craziness. Whoever was dealing with this case, craziness. I'm not trying to slander anybody. So it was reversed on appeal in various respects. I don't know what happened on a retrial. I don't know if it was settled or what have you. But Mr. Bachman, who has had a challenging life, obviously, and some poor decision making apparently went on the apartment building owner's part, wound up getting zapped for a huge amount of money, right? A huge amount of money. So the answer there is if somebody asks for a reasonable accommodation with respect to snow removal and housing, you must immediately start the discussion of what is a reasonable accommodation. Does that mean that a handicapped person or a disabled person, I should say, gets anything they want? No, no, they don't. And the court says that. Just because you're disabled doesn't mean you run the world, right? But you have to allow a reasonable accommodation so that the person can enjoy the housing elements that they're entitled to, as would anybody who is not disabled. So I just highlight that because when I pulled through that case, I was like, wow, that is a huge verdict. And even though it was an apartment complex, the analysis is very similar. The second case is the Scott Meyer versus 10 Mile Island Condo Association. That's the Colorado case. So again, first, it's the second paragraph actually of the case. This is a discrimination and retaliation case filed by Scott Meyer, a double amputee who uses a wheelchair for mobility, against his homeowners association and its former board president, former property manager, and former property management company. In a nutshell, plaintiff alleges that between 2019 and 2020, he complained to defendants about inadequate snow removal around his residence and the associated parking areas. Again, the court opens that with a double amputee that's not getting proper snow removal. You know you're in trouble already. It's not going to be a good day for insurance defense counsel. Plaintiff described in his statements the difficulty and physical pain he experiences propelling his manual wheelchair through heavy snow, right? I mean, think about that. You got a guy in a manual wheelchair and they're not taking care of business with him. So this one, it was on a motion. The decision was on a motion, so it didn't report on the verdict itself. It's just another example where courts and juries are not going to look highly on an association under the Fair Housing Act, where the association doesn't make reasonable accommodations for the person's disability. The one thing to keep in mind, though, is people need to communicate. Right? They need to communicate. I have a disability and I need an accommodation. The association is not expected to go around and survey everyone in the world and say, hey, are you disabled? Are you disabled? Are you disabled? Are you disabled? No. And also the association is not obligated to implement a one-size-fits-all policy, because one size does not fit all in terms of disability case law, right? So associations have to make people aware, the residents aware, that they do grant reasonable accommodations, but people have to come in and say, hey, what's going on? How should we handle it? What do you think? And then between management, the board members, if you have a committee who you want to use to discuss these issues, you have to work your way toward a reasonable accommodation. The most dangerous thing for any association in the disability field is just blowing people off, right? Not responding or giving nonsense answers or saying stupid things. That's why I said don't be foolish. Like, you're not really disabled, you're fine, right? No, that's just craziness. So anyway, that's something to be very much aware of. I'm going to go to the chat now. Let's see. Mike says thanks. Mike Epps, you're welcome, Mike. Thanks for coming. Carol says, "Oh, beautiful dapple doxy. I didn't even know what a dapple doxy was, but that was the dog of the day today. Very fancy." Um, so Len says, "What if an ordinance states that owner of premises abutting any street in the township shall remove all snow and ice within 24 hours, but the sidewalks are in fact private property? Would such an ordinance be grounds to punish a failure to timely remove, even if the township doesn't own or maintain the sidewalk?" So that's a good question. Let's look at the sample if I can find it again. Each owner and tenant of land abutting or bordering upon the sidewalks of any streets or public places shall keep the sidewalk in front of his residence in a safe, passable, and orderly condition, free from snow. In case of snow or ice, sidewalk, such person shall remove the same within 24 hours. So that's a good question, and this ordinance is not clear. So arguably the sidewalks of streets or public places. So it's an or in the brick statute, and in the Lakewood ordinance, I haven't read the Lakewood ordinance yet, but they were citing the association for private sidewalks on private property next to private streets. So I think you're still, even though the ordinance itself might not provide a cause of action for someone who got hurt on the sidewalk, the ordinance itself, it may still mandate the removal of the snow. Like I said, in Lakewood, the municipal inspector took the position that the ordinance does apply, even though the sidewalks are within the community and they're private. It goes on to talk about private and semi-private roads and streets and other premises used by tenants and employees of the owner thereof. It's not clear, and I don't want to get into subsection B too much, because there's an argument that can be made that they were really aiming that at commercial properties and apartment buildings. But like I said, at least in Lakewood, at least for the moment, it seems like they are taking the position it does apply to sidewalks within private communities owned by the private community. And I imagine if they wanted to, Brick Township probably could take the same position. But again, you're looking at ordinances and summonses and fines under the ordinance. So, hi, Mike again. Maybe Fran can informally opine if he gets a moment. Oh yeah, so I gave Len's thoughts there. I think the township could enforce the ordinance, Len, if it wants to, and the association would have to go to municipal court and fight it out if they find you. So that's the problem there. I think probably most townships just don't enforce them, right? They don't enforce them diligently. What happened in the case that I'm talking about is, and people do this all the time, right? They think, oh, I will show this association. So the residents in their own community called the township, right? So if you shoot yourself in the foot, don't reload and do it again, right? Because now they're paying lawyers and they're paying the township fines, right? So they think they were being wise guys, I think. And the township comes in because they're getting all these calls and they go, okay, well, that's fine. We will give you what you want. Here are a bunch of summonses issued to your community. Now pay the fines, right? So, and what happened there, in addition to that, I won't name names, but what happened there, in addition to that, was the association was actually in the process of clearing the snow. But as you recall, it was a crazy snowstorm, and then it froze with that layer of ice over it. So they were doing their best that they could to do it in a timely basis. It wasn't like they blew it off. They were working very hard. But in response, the association went out and hired a supplemental vendor to do it even more quickly. And I think that they needed that in any case, honestly. But they hired a supplemental vendor, and the supplemental vendor, like probably all of you, wound up costing them a whole bunch more money. So it's, people have to be careful what they wish for. Al says, if the association maintains the sidewalks and the governing document mentions snow removal by the same, does the association fall under the town code for snow removal in a timely manner? Like I said, Al, I think so. So I think if the association owns the sidewalks, I think the town can take the position that the ordinance still requires the snow to be removed from those private sidewalks. The issue there, though, is the ordinance itself doesn't provide a claim for an individual, right? So Len says again, that's kind of what I meant. We do maintain our sidewalk, but our township requires 24-hour removal, which just wasn't possible. I agree with you, Len. People were just overwhelmed given the blizzard, and there's no municipal exception for extreme circumstances. We got criticized by residents for violating the ordinance, but I'm not sure we did. So we're taking the position in the Lakewood case, and we're going to fight the summonses and the fines. Taking the position that it was an act of God. It was an event. It was a blizzard. What are you going to do? I mean, even the state declared a state of emergency, right? So it was a state of emergency, and we have people, again, people who, we'll say some people are somewhat unreasonable, right? Did you really, 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 really need to take a walk around the block in the middle of the blizzard, or within 24 hours after the blizzard stopped snowing and everything turned into a skating rink? Probably not. Probably not. So did it make sense for you to call? Probably not. But there were people who did have serious health concerns. There were people who had serious doctor's appointments and needed treatment or needed aides to come in and so forth and so on. And they apparently suffered delays, which is a real concern. So I don't mean to diminish that in any way. It's just that on the disability side of things, it really requires pre-planning and long prior, in my opinion, request for reasonable accommodations, right? So people know who needs to get out, or people need to know who gets in for a reasonable accommodation. The other thing that we were seeing a little bit, and prior to this snowstorm, just as an aside, nothing to do with snow removal, was some people who were on oxygen, but they did not have generators, were looking to use portable generators to run oxygen. So you have to think about those types of things when you have bad weather events coming, because at least one example, the association prohibited all portable generators. So what do? Do you go stay with a family member if you think the power may go off? Do you buy bottled oxygen? What do you do? So does the association allow a temporary exception for portable generators? One of the issues that came up, which I had never seen before in the last storm, was, Fran, now we understand that gasoline power generators that are portable cause a significant fire hazard, but they now make propane generators that are powered by the propane tank that you see on gas grills. And at least the position of some people was, the safety hazard is no different than a gas grill, so why can't we just have our portable propane generator? Anyway, just put a bug in your ear about that. We don't need to get into it any further today. If a road is private but used by residents and the public, does it become a public right-of-way? Does the sidewalk stop at the driveway and continue after the driveway? So that's Julie. Thanks for coming, Julie. So that's a good question. That really relates to that last case that I mentioned, which was the Walder versus Piper Townhouse Association. In that case, the court said, based on the facts, that the road, even though it was owned by the condo association, it was used by the public and residents, and more or less the court said, it's a public right-of-way. I don't want to hear your issues about it's a common element. It's not a common element. It looks like a duck, it walks like a duck, it quacks like a duck, it's a duck. So we're going to call it a public right-of-way. But you can't rely on that in your planning, so you still have to make sure you have insurance, especially if you're owning it. So the other question that Julie raised was, does the public right-of-way stop on the sidewalk? What happens with the driveway apron? And I'll flip to show you again. So in this illustration, and I'm not an engineer, so the engineer would actually have to measure it. You see the right-of-way, and the right-of-way actually encompasses the sidewalk and the driveway apron. See that? But again, I don't know if there's case law on what if Mary Jones or Bob Smith fell on the apron here rather than on the sidewalk. What would a court say? I haven't seen a case on that yet, but at least from an engineering standpoint, it looks like the state of New Jersey is saying that the right-of-way, if it reaches that, depending on how wide the right-of-way is, would encompass the sidewalk and the driveway apron. you would have to talk to your engineering firm about that as well as your insurance carrier. I think the insurance carrier would just direct you to provisions of what's covered. All right. Bill Ferguson says, in a co-op, the co-op owns the streets, the sideways, the driveways, the clubhouse, the parking lots, etc. If a proprietary leaseholder slips and falls, isn't the co-op responsible? No immunity. I think you're right there, Bill. We have probably 5, 6, 7 co-ops, and I think that the corporation, if you will, the co-op corporation will be liable. I'll check on the immunity statute. I'm not sure that the immunity statute applies in co-ops. I haven't seen it, but I'll check just to make sure it's not. I have not seen the immunity statute in co-ops. Are associations responsible for costs related to RA? RA. I don't know what RA is. I'm sorry, I'm ignorant. But Mary, if you could tell me what RA is, I'll try and help. Great topic, Jeannie. Thanks for attending, Jeannie. What if a disabled person lives with somebody who is not disabled? Should that person assist with snow removal? Should that assist? No. So generally speaking, in association world, the residents are not tasked with snow removal, depending on your documents, of course. But unlike the city of New York did in this past snowstorm, we're not looking for volunteers to line up at the township or the association's clubhouse, and we'll give you $1,500 a piece to shovel snow for us. We're going to use professionals. So, and I don't think it will be a sufficient answer, Bonnie, unfortunately, to say, "Hey, disabled person, get your husband to shovel you out, would you?" It's just not. It's not going to fly. So you'd have to make a reasonable accommodation. And in that case I was talking about where the association got the summonses, thank God, in that association, neighbors and friends, etc., did help the disabled people. So the disabled people who needed to get out were helped by their residents, by other residents, and the association's vendors and employees to get them out. So Bonnie, yes, people can help them if they want. If the association just should not do that as a policy. And we had several requests during that storm to say, hey, let's just get our people out there. And we want to use professional snow removal people. We don't need people having heart attacks in their driveway. Larry says, our association has a priority list of 45 homes. They are cleared first, but it takes time to get 45 homes. Also, do we not start clearing driveways until the snow stops? Do we need to revise our accommodation? So Larry, I look at those 45 homes, if you've gone through the process of a reasonable accommodation for a handicapped person. It's interesting that you mentioned 45 homes, right? Because you're right. Nothing is done instantly. And if you're making the 45 homes a priority, it may still be, some time before you get to the 40th home or the 45th home. So I've actually been involved in a case in Ewing, New Jersey, and it was a parking case rather than snow removal, where people were fighting with each other as to, I am more handicapped than you, and I'm more handicapped than you, and I'm more handicapped than you, God damn it, right? So it becomes a problem, right? But the association has to handle it case by case, and has to make a call for a reasonable accommodation. So what was happening at this place in Ewing was, as people became less and less abled, they would claim that they need a parking spot closer to the door than the other disabled people, right? Because I'm now more disabled. And the association never implemented a general policy. They did parse the disability of people, but not all the disabled people who live there asked for a reasonable accommodation. So this was probably 20 years ago, at least. And one of the residents, believe it or not, was a World War II veteran there, and he was very badly disabled. And he refused to take a handicap spot. He refused to ask for a reasonable accommodation. He would stumble and fall all the way across the parking lot to get the front door. That's just who he was. So just because people have a disability doesn't mean they're always going to request an accommodation or in fact want an accommodation. But like I said, I don't know how the 45 people in your example got their accommodation, but I would say it's person by person. So one of those 45 people, for example, may be much more disabled and may be much more in need of a quick clean out than, say, one of the other people. So you have to make the call on that. Len says, thanks. Al says, thanks. Thanks for attending there, Al. Rick says, we have not been clearing sidewalks after snow. Are we liable if someone is injured? So, Rick, the answer to that is a very legal answer is you may be. That's the problem. You may be. You would need to develop the facts a lot more, Rick. So we would have to look at your governing documents. We'd have to look at whether the roadways are public. We'd have to look at all those fun things. Julie says, so the association should send out a notice asking residents to notify them if they need special accommodations. So I don't see associations sending out notices that say, hey, please let us know if you're disabled. Generally, my experience has been people with disabilities come to the association and say, hey, I have a problem. Would you please address it? And the associations that I work with do. So that's good. I don't see people sending out broad, hey, if you're disabled, let us know. But certainly if somebody is disabled and they have a request, you certainly have to engage in the dialogue and make reasonable accommodations. If a sidewalk is owned by a resident of a non-condo HOA, but the association does maintenance work on, such as shaving down uneven slabs on sidewalks, does the HOA incur liability for any future trip and falls? So this isn't a snow case. This is by Dave. So again, it's a lawyer answer. And what Dave's alluding to is if an associate, and let's assume Dave's example, the association has no legal obligation to touch the sidewalks. Let's assume they're on the lot of the HOA owner and the owner is responsible for it. But the association, because they're nice people, says, hey, we're just going to go out there and address trip hazards. The answer to that question is if a party, whether it's an association or an individual, undertakes a duty that they don't have, they must do it with reasonable care. So if an association goes out there and undertakes to mill down raised sidewalks and doesn't do it right, as alluded to in Dave's question, you may very well incur the duty by undertaking the duty and the liability that goes along with that if you don't exercise reasonable care in doing it. So that's a good question, Dave. Be careful what you volunteer to do if you don't have a duty to do it, because you will undertake liability if you don't do it reasonably. So Carol mentions reasonable accommodation again. Bonnie says, thank you, Fran. When seeking to be on a disabled list, it's a fine line with HIPAA rules with association requesting proof. So Al's question, and we can talk about this in another webinar, but so Al's question is the difference between disability and disease generally, right? So somebody may not be able to walk because they have MS. Someone may not be able to walk because they are an amputee. Someone may not be able to walk because they have advanced AIDS and they're too weak to walk. I don't need to know as an association, do you have AIDS? Has your leg been amputated or do you have MS? I don't need to know that. I do need to know from a medical professional that there's a disability there and I need the following as a reasonable accommodation, right? So we try to stay away, but many people volunteer it anyway, Al, the actual source of the disability, right? So the disability and what caused the disability are not necessarily the same thing, if that makes sense. The one thing to keep in mind, though, is be careful when you go to an open meeting. If someone gives the association, and obviously, it's a much different disease now, but I've had associations where we had people who were advanced stages of AIDS who were in very bad shape. And the last thing you want to do is say, he gets the handicap parking spot because he has AIDS. No, that would be craziness. No, right? So if the association is given information on things like a disease, a disorder, a health problem, the association is not going to disclose that, right? So you got to be careful in lots of ways. So Mary's question about if an association is required to take on the cost of RA. Oh, reasonable accommodation. So the cost of a reasonable accommodation, thanks so much, Carol. Um, and thanks, Mary, for the question. So the answer is the association may be able to take on the request of a reasonable accommodation, may. Um, that generally is, let's say, nominal costs, and it usually involves practices and procedures, policies, rules, regulations, etc. So when Mrs. Jones gets her snow cleared out, the differential cost in sending a truck there first or last, there may be some cost associated, would generally be a cost borne by the association. Where you see costs being borne by the person who requests a reasonable accommodation is an actual modification of a physical thing. Like, I need the association to change the rules and regulations for modifications because I want to build a ramp up to my porch for my wheelchair. Generally speaking, the association would be compelled to allow the building of the ramp, but would probably not be forced to pay for the cost of the ramp itself. You see what I'm saying? So it would be a modification, practice and procedure, rules and regulations, et cetera, but it wouldn't force the association to pay for the ramp. Those questions, though, you have to be very careful with. So on every one of those questions in terms of who bears the cost, you should speak to your lawyer, right? Because there are kind of close calls on that sometimes. Oh, hi, Emmy. I see Emmy there too. Emmy, we'll talk next week about your 3 estate cases, or you might even have 4 now. But that was the last question. It's good to see everybody, and happy spring, happy daylight savings time. If I'm missing any, I think I'm missing some holidays, but if I miss other holidays, happy holidays to everybody, and have a great weekend. Thanks again for attending. Bye bye.